Hello, welcome back. GovDoc Breakdown, no opinions, just facts and summaries of government documents, and we let you just take it from there. So, May 27th, Supreme Court opinion on an order, LM v. Middleborough. All right, so this one is intriguing and puzzling and kind of thought-provoking all at the same time. There were two dissenting opinions written in this case, one from Alito and one from Thomas. And they wrote these dissents after the Supreme Court denied hearing the case moving forward. So they were denied certiorari. But before we go any farther, we need the background of the case. So the LM in LM v. Middleborough is a 7th grade student from Middleborough, Massachusetts. LM wore a t-shirt to school that said, quote, "There are only two genders," and was told to take it off because it upset some students. Later, he wore another t-shirt that said, quote, "There are censored genders," to protest the censorship, but that t-shirt was also banned. School officials said these shirts targeted and demeaned transgender and gender non-conforming students, causing a serious negative impact on them and risking disruption on school. LM argues that his shirt simply expressed his viewpoint that there are only two biological sexes, and that he was not disrupting anything or harassing anyone. So, let's go to the courts. The district court agreed with the school, saying the shirts could be banned because they invaded the rights of other students. That was appealed to the First Circuit Court of Appeals, who also agreed with the school, but for different reasons. The First Circuit said the shirts could be banned because they might cause, quote, "a material disruption in the school environment." They also created a two-part test for figuring out if something could count as a material disruption. One, if the message is seen as demeaning a core personal identity like gender or race. Two, if the message is likely to seriously harm students' psychology and thus harm their learning. The First Circuit concluded both parts were met and so sided with the school. A little bit weird that they can create the test and apply it to the case that they're trying to figure out, but that's not my job. That's not my business. So then we get to the Supreme Court, which declined to hear the case or denied certiorari, which means the lower court decision stands. This is what catalyzed the dissent from Alito and Thomas, and these dissents centered around the main question of whether schools can ban student speech just because it expressed a viewpoint the school dislikes or because of vague worries around disruption. They talked about a case called Tinker v. Des Moines.
Full video located on our channel.